Welcome, everybody. Welcome, everybody. It's Tuesday, February the 26th, 2019, and it's 11:03 a.m. Welcome to the Case Review Committee. 11:32, excuse me, a.m. Welcome to the Case Review Subcommittee meeting. I'd like to call this meeting to order. Do I have an approval of the agenda?
I move that we approve the agenda.
And I second. All in favor? Aye. Did you get the opportunity to review the minutes?
No, I didn't, but I vote with you. It's fine. I'm sure they're fine.
I just reviewed them. Okay, do I have a motion?
I have a motion to approve the minutes.
And I second. All approval?
Aye.
Say aye. Next we have public comments. Mr. Jim Larson, please.
I'm going to just pull up a chair, man.
I don't think it'll be that long. Let's see. I have copies. I'm just going to do one at a time if we talk about them. Chelsea's not here. You like one, Ed?
What is it?
Just a handout.
Sure. I just want to be on the record that I think that presentations regarding a case that the board has not reviewed yet is inappropriate, and that this falls under ex parte communication, and this type of communication going to board members prior to the full board ruling, I don't believe is appropriate.
Okay, so noted.
Okay.
Okay, this first
Is
is
it the
just
same
an
as this?
introduction. Yeah, it's a status. It's just an introduction to something I think that you're going to find interesting, and I don't think you've seen before. The trial starts for dad accused of prostituting a girl. That was in the Journal paper this morning. The dad was arrested on May 2nd of 2018. CPO case 13218 remains open, awaiting resolution of POB request for additional information. I think the case has been presented to the Police Oversight Board. And,
We have not voted on it.
that's right. The citizen complaint was filed on May 30th of 2018. The public record letter that outlines the findings and recommendations for this case was on the POB amended agenda on October 11th for the 2018 meeting. The POB has returned the investigation twice, and only recently the Case Review Subcommittee returned it once to the CPOA in attempts to determine if all applicable SOP violations have been reported. The POB also wants to know if the incident suggests that APD should revise strategy, tactics, identify the need for additional training, counseling, or other non-disciplinary corrective measures, or suggested revisions to policy. The CPOA did not make any of these assessments due to the time constraints and has not yet as a result of the POB requests. This is what's the heart of what I want to tell you and give you. APD initiated 2 special orders on June 16th, 2018. June 6th, 2018. Detailing with historical contacts with juvenile families and collection of evidence based upon APD response to the incident in the complaint. This was not disclosed in the records provided by CPOA in my response to IPRA or APD in my response to IPRA. I've not seen or heard of it on any of the information provided to the subcommittee or POB by CPOA.
Actually, I brought it up. I brought it up at the last meeting, and we just got it. I got it from the meeting that we had with the chief, chief staff, the deputy chief, and gave it to Mr. Harness, so they didn't have it.
Well, that's my whole point, is I got it through an IPRA request last Thursday. And the importance of it is the whole heart of my complaint was the fact that they didn't have enough historical information to make a competent decision on whether these kids should have been taken into custody or not.
How does the special order affect that?
Well, yeah,
So go ahead.
okay. The special order.
We can't do this all morning, though.
Yeah.
We have a meeting, so we have to get to it. So
The
let's get
special,
to the heart.
okay, the special order says, use of CACU management system and CYFD law enforcement portal. Effective immediately, all officers encountering allegations of child abuse or neglect on any call for service or field interaction will contact the RTCC and request a query for information through both the CACU case management system and the CYFD law enforcement portal. This approach to information gathering by officers in the field will alert them to the possibility that a child contacted in the field has a history of being abused or neglected. That was done approximately 1 month after the children were arrested by the
children
AG.
were arrested?
Well, the parents were arrested by APD, by the...
Mr. Larson, you're covering ground we already know, so I want to know what's the heart of what message do you want to get to us now? What's your objection today?
Well, Member Fine, I will say that I don't think you already knew this until about a week ago, and this has been June 6th of 2018.
We've known it since February 1st. It's when I got the special orders from the commander of the Family Advocacy Center, whose name I can't remember. Is it Dugan?
Lieutenant,
I can't think of his name. In any case, at the
no,
meeting
that's,
we had with them, which we
Commander
initiated, they gave us the special orders the first time we got it. So the staff didn't have it, we did have it, we distributed it to the board. It's something we're going to talk about here, and in fact, in March, the lieutenant from the CACU is going to come and speak about those special orders, and also about what else they're doing and what they're doing with CYFD, which I talked about at our last meeting, our last board meeting. So none of that is new information to us, and it's just not something we knew at the time you filed your case. So tell me what else is here that we have plans for dealing with this, where we are dealing with this, and I'm not sure what I should be learning here.
Well, I never saw in any of the, I don't recall in your presentation that you brought this to the attention of the board, and the fact that it has been in existence for almost a year and you all weren't made aware of it when you have asked the CPOA to relook at this. And in fact, the CPOA is supposed to provide you, when they do their recommendations, with issues of whether there was more training needed if the police department had done anything. In fact, we didn't know that the police department was doing this or had ordered this. It also has a bearing on the fact that my complaint was that the RTCC did not follow what they were supposed to follow. And if we had known any of this, it probably would have not necessitated further investigation or further requests. And I don't guess I need to provide anything more, because it's obvious. I mean, I believe it's obvious that you at least have made your mind up that this is all being taken care of properly. And,
No, I'm not at all saying that. I would say to you that we discovered this special orders. In fact, I did mention specifically special orders. If you go back and look at the video of the board meeting, I couldn't remember what they were called. And so we did do that. We in fact talked to the police department leadership about coming to our board meeting and talking about this, specifically for the reason you say. And I specifically asked the questions at this last board meeting about the RTCC piece that you brought up. I mentioned you by name. So we are grateful. We have followed up on your concerns. We've followed up to the point that we've discovered this new information. And we've asked the police department to come to our March meeting to discuss those special orders and to talk about what else they're doing within the department and with CYFD to hardwire their relationship so we don't go down this road again. So we have taken your feedback very seriously, and I object to you saying that I'm not listening to you, because I have all along listened to you.
well, I don't mean to, I think that when I say, you're absolutely right, you have been listening to me. My concern is that you rely, and they complain that you're not relying on the staff. And the staff should have found this July 6th memo and given it to you.
I hear that's your opinion. I'm not sure I agree with it, but I'm willing to take a look at what that is and when that is.
Okay.
All I know is when I found it, I gave it to the staff, they distributed it to the board, and it's on our agenda, so to discuss in March. I think we are absolutely keeping up with it, and I think the staff is keeping up with it as well. This is not an easy matter, and overarching the 3 cases are not easy matters, and we all know that it's likely there'll be other cases. We want to fix this system, we want to hardwire it, and what we learned at that meeting, and I would encourage you to go back to our February board meeting, because what we talked about was this can't rely on personalities. It can't be that we have a good administration for APD and now we have a different CYFD thing, so now it's going to be great. This has to be hardwired. And you and I agree on this.
No, I agree wholeheartedly. I think it has to do with more with what does it mean when you do a welfare check. There has to be more to it than just going and saying, oh, well, I went to the house, but the kid wasn't here, but the mother said she was with a sister.
Well, and there may be, and I believe there have to be policy and procedure improvements on this, but it's more than that. The commitment has to be overarching no matter who's in charge of APD, no matter who's in charge of CYFD. We can't have this anymore. And you brought up some really good points, and this board and this committee has really taken what you've offered to heart.
So
I think that it is wrong to assume that there is anybody in this process who doesn't care about it as much as you do. We do.
I didn't say that.
Well, I'm saying it affirmatively. Everyone cares about this as much as you do. And your insistence that the CPOA staff should have or could have known something, we don't know that. What we will find out, just as we have taken every other one of your concerns to heart, we will take this one to heart.
Well, they didn't take my concern on the RTCC to heart because they didn't even answer it in the complaint. It was in the complaint, and you have asked them to answer it.
And they did answer it at this last board meeting. I specifically said, explain to me how this is. And what we learned, the learning moment, which is what we're looking for, not punishment, learning, okay? What we're learning is that the RTCC did not organize their information by name, that this family was transient. And they were from here and there. So when they called RTCC, they had only those things that were at whatever address they put in. That's what changed. So if you've seen the special orders, one of them is you can't do it just with that. You have to do it by name too. And that is a significant change. Very significant. So to my way of thinking, even though you shake hands and agree that from now on you're going to do all this, it doesn't change today. We're all grown-ups. We know it doesn't change today. The word doesn't get out to everybody today. Are they responsible for it getting out? Absolutely. Are we all responsible to make sure it works? Absolutely.
Well, I just have a couple questions then. One is, you say that the RTCC could not check them by name, they had to check it by address.
They did check them by address. And because these people were transient, they only got a fraction of the story.
So they didn't check them by name?
No, that wasn't their practice. They changed their practice. That's what the special order is about.
Okay, so, well, I have some, well, I'll present that later at a public meeting. Well, I'll just give you an example. I don't think that, my concern is that, quite honestly, my concern is you don't seem to think that it's, would be appropriate that in the context of this investigation that the staff would not have found these special orders as something that they might be evaluating my complaint against. If they had, I think it would have mitigated my complaint rather dramatically.
That may be, but they didn't have it, okay? And they didn't know about it until I brought it to them, till Ed and I were at a meeting with them.
That's my whole point. When you,
so anyway, this is the kind of communication that I think is completely inappropriate for a case that the POB has not even ruled upon yet.
We're not
These are-
going to make any decisions on this right now.
I understand that, but these are issues that if Mr. Larson has an appeal, once the board rules, then those are the issues that he can bring to his appeal. It's completely inappropriate for him to be making a case before anybody who's going to rule on a case before they've ruled on it.
Well, I think this is a process question, and I don't think it's a case question. So my reason for having this conversation is because we are asked for public comment. We ask for it. We can't shy away from it once we get it. So my point is, process-wise, I think we have been very diligent about this, and both as a board and as the staff. And so now we have the letter from the chief that says they agree with this, they don't. One of the things that happened at the last meeting is we said, we don't understand what the chief said because it's a list of numbers. So we're going to be digging deeper into that. We're not done.
Okay, I understand that. So if I were to IPRA the CPOA, this letter would have been sent to the board already.
I don't know what the rules are as far as us sharing special orders with the police department. I don't know the answer to that question.
I'm saying to the board.
Well, they're not our documents, and so if you're asking me, can we as a staff or a board share their special orders? I would imagine they're public record, but I don't know. If you want the special orders, ask the.
I did get the special order. Through
Okay, then you got it. So it's all good.
Well, I'll just leave it with this: that I will tell you that at the last meeting, and this was a public meeting, and Director Harness said that to you all that the CAC unit conducted a forensic interview of the kids. The IA investigation says there was no forensic interview done of the kids.
Well, I appreciate your telling us that, but as Mr. Harness has said, we're not discussing the merits of the case. We will take that under consideration. I will thank you for your input, and I will check that.
Okay, well, then I see that what would be considered appropriate for someone to bring the committee to this committee is a public comment.
Anything you want to say doesn't mean we have to respond to it.
I think that there has to be an understanding that public comment from someone of the public versus public comment from someone who is a complainant on a case that the board still has to rule upon has a different standard.
Okay,
I think you as a former law enforcement officer understand those ethical standards and should appreciate those boundaries. Because there is a process that needs to be followed, and the process that needs to be followed needs to be fair to all parties, not simply the complainant. The board is not an advocate for the complainant. The board is a reviewer of independent facts. And that's the crossing of the line here.
Okay.
That's the crossing of the line here. You are not the general public at this point. You are the complainant in 132.18. That's a different standard as opposed to if Mr. Arisum made comments, because Mr. Arisum at this point is a member of the public. He is not the complainant. He is not a party to 132.18.
So somebody could make a case
those processes,
that you're
those
lobbying
standards,
us to
those
come
need to
to
be
your
adhered to,
decision.
because we have to be fair to all the parties involved here.
Okay. So then if I want to bring this to the board's attention and they haven't voted on it, I can still do that?
You have the right to do that when the case is on the agenda. You are entitled to 5 minutes to discuss the case when it's on the agenda.
Okay. I'm going to shut up and I'm going to clarify that as a former law enforcement officer, I don't agree with your decision on appropriateness or ex parte. My view is, and since you brought it up and were chastising me about it, is that I don't view this as ex parte because this is a committee that's going to hear information and they're going to make a recommendation to the board. Their recommendation to the board is no more than a recommendation. They are members of the board. They're going to make that recommendation. So I don't agree. I agree with Member Fine when she said, I guess people could perceive it as lobbying. I perceive it as providing facts that I didn't know you had and that you didn't have until February 1st.
Right.
And also providing a correction to explanations that have been provided to you at the board by Director Harness. And you don't want me to do that here at this meeting, and so I won't. I'll do it at the public meeting. And I'm finished. I don't
Mr.
have
Larson,
anything
you're
else.
here advocating a position, and you're here advocating a position, and you're here presenting things that you believe to be evidence. To be fair, all of the parties involved in this case would need to be here to hear that.
Well, they can hear it, these people can present it they represent the board.
You could not walk into a judge's chambers and have this conversation with a judge.
You're not a judge.
with-
These people aren't judges.
They're-
And I'm
But
not-
they
I
are,
don't- I mean,
asked to make a ruling.
Mr. Larson?
They're asked to make a
They're asked to
recommendation.
make a
A
ruling.
recommendation, not a ruling.
Okay, this,
I'm done. And I think it's very informative that, quite honestly, that this has been sent back to this gentleman 3 times. It's not on your agenda today. So when is the case going to be resolved? They're taking the case to trial on the father, and we can't get the CPOA to answer your questions.
actually, we are getting them to answer our questions, Mr. Larson, so I disagree with you there.
Okay, thank you.
We'll see you later, Charlie.
Okay, next we have Charlie,
Mr. Erickson.
Mr. Harrison.
Sure, last POB meeting, you had a gentleman speak during the public comment period concerning a complaint that he had filed with your executive director that was apparently refused, rejected, I don't know what. So I'm here today to verbally or orally file 2 complaints against your executive director for not following the ordinance or the CASA that both require all complaints filed with the CPOA to be investigated. Last year, I filed 2 complaints with Mr. Harness, and they are here. One concern that he rejected. One concerns a police officer that was found to have driven his patrol car, crashed it, abandoned it while under the influence of alcohol. That office, at the time of my complaint, which was February of last year, I was complaining about what the current command staff at APD was doing concerning an SOP that requires the immediate termination of an officer found to have driven his patrol car under the influence of alcohol. That complaint was rejected unilaterally by your executive director, not investigated at all. And
By that, do you mean it was administratively closed?
no, ma'am. He rejected this. There was no investigation. There was nothing. He did nothing. He
Okay, I heard
rejected
you.
my
I
complaint.
heard you. You've got 3 minutes. So
Which is against the CASA and against your ordinance, okay? So here is that complaint from February of last year. Now, in May of last year, I filed another complaint that Mr. Harness completely ignored. I have no records of him responding to me at all. And in that complaint, I attached, it was an email, of course, I attached about 70 pages of information. And this goes back to the very beginning of the Police Oversight Board holding meetings. At the very first meeting back in March of 2015, there was a case where an officer accessed the NCIC database
I remember it.
and gave information to an estranged boyfriend or husband or whatever it was, and placed a woman in jeopardy. And she filed a complaint about that, and the board took some serious looks at that, okay? Well,
That's your 3 minutes.
in that, I'm almost done. In that investigation, it was found that the officer lied about her accessing the NCIC database. Under federal law, it's my understanding under federal law, that when a police officer lies in an internal investigation, that information is supposed to be sent to the local district attorney's office. It's commonly referred to as the Brady list, okay? I filed a complaint in May of last year that Mr. Harness completely ignored. I got no response from him whatsoever concerning APD's policies on the Brady list. They have none. And I provided him all of the information in that email of my complaint that was completely ignored. So here is that complaint.
Okay.
Like I said, along with these, I'm refiling these with you now, okay?
I don't think that's the right way to do
That's-
this.
that one-
We
Well-
need to do it with them.
Well, fine.
You're letting us
Okay,
know.
I'm
I get
letting
it.
you know, and I'm doing it publicly
Okay.
so that there can be no arguments that these were filed. Now, I have a third new complaint that I am filing today in public so that there's no argument that they hasn't been filed. And this concerns some more information that's come out in this case of the 7-year-old girl who was prostituted by her parents. So there is a copy of that for you, and there is a copy of it for Mr. Harness.
Thank you, Mr. Harrison.
Thank you.
Okay, so Director Harness, so he submits these to you then, complaints against you, or how does it
I'll
supposed to
just take
format?
them and we have them.
There's no way to discuss it right now.
Okay, no, I'm just asking for formality, I mean, what's the procedure here?
Yeah.
Okay,
Well, I have them, so.
okay, thank you. Okay, well, you're finished with public.
We would expect, Mr. Harness, that we would hear from you in the appropriate time frame for all of those cases, in terms of your decision
Yes.
and your staff's review.
They will be input into the intake system and they will be handled within the
Thank
complaint
you.
process.
Okay, thank you. Okay, now we have the review of cases. We had administratively closed cases. The first one is 125-18.
Do you have any that are standing out to you? Is that the one that you're talking about, 125,
18, yeah.
025, 18? 19.
So our first one is 125-18. This is, that's this one down here, the one that we're going to see.
So Ms. Vandervender, though she is not here, sent us a complaint, or concern about that case.
Let me read this.
Yeah, why don't you
Okay,
read?
this is what she sent for us to read. This case should receive an investigation and not be administratively closed. Here a woman complains that she sees an officer
That's
at
not the one, this one.
125-18. This, no, this is it.
125, 19.
Oh, you're doing 19, I was doing 18, the first one, 125-18, right here.
Wait a second. Oh, okay. I thought this was her letter. Okay.
Yeah, this is.
Okay, I'm with you now.
Excuse
I'm
me.
with you now. Okay.
This case should receive an investigation and not be administratively closed. Here is a woman that complains she sees an officer at Fuddruckers and that she witnesses him meet a woman there and then leave the restaurant with her while he is waiting for his food. Then she says she witnessed the officer engaged in a sex act with the woman in the woman's car that her children witnessed. The CPOA is able to confirm that the officer did go to Fuddruckers the same day, and complaints say she saw the officer there, but the case then gets administratively closed. The category we made up for this administratively closing is a case, for instance, where the complaint cannot minimally be sustained. The complaint is minimally sustained, so administrative close is not appropriate. Further, the CPOA prefers that they have not been able to reach the complainant. However, an interview with the complainant is not the only component for an investigation. In this case, the officer should have also been interviewed, but I do not support administratively closed case. My request would be that the CRC refer this case back to the CPO to investigate, and that the CPOA agrees to accept them back at this stage. If the CPOA is unwilling to do that, I would ask that the CRC recommend that these cases be placed on the non-consent agenda, so I may make a motion at the next full board meeting to refer the cases back for investigation.
Okay, so I want to hear from you, Mr. Harness, because I had similar concerns. I didn't understand why you could administratively close this just because you didn't get, I mean, it looks like you verified that the officer was there, this woman is complaining about something she saw.
Right.
So it's a pretty outrageous claim.
Right.
So tell us about it. Why would you administratively close that?
Well, we're administratively closing it because we haven't developed any evidence to substantiate what is in the complaint, aside from the fact that the officer happened to be there.
So wouldn't you want to interview the officer? I don't understand.
Well, no, I would rather have the complainant come forward and tell us what she observed so that we can interview her live, get her statement, and then move forward with the investigation. We did attempt to get surveillance video. We did attempt to make other means of verifying what is in the complaint, but we need to have that stepping off point from this complainant to say, this is what I saw, this is the description, this is what I believe this person looked like. We need the complainant to come forward and give us that information.
But hasn't she done that in the complaint?
Yes, but that's not evidence. Simply making an allegation in a complaint is not evidence. She needs to come in and give us an actual statement so we can interview her as to the veracity of her statements.
Okay. It seems to me that this is a pretty egregious complaint, and that it would warrant, it seems like a quick dead end to say if we don't hear from her, that's it. Is that the communication you had with her? If we don't hear from you,
Yes.
we can't go anywhere?
Yes.
Okay, and what she
By
said?
email and by phone call, and then there was no response. She responded one time with a phone number, left phone messages, emailed back, and there's been no response since.
So if you can verify that he was assigned there and that he ate there on the day that she complained, is there nowhere else to go with this? I mean, would you not consider sharing that with his sergeant or something? No, because there's no proof.
No, there's no proof, there's no evidence. Simply because somebody makes allegations, that's not evidence, and we need that stepping off point. I believe if we're going to go down this road, that's going to put, if we're going to go down this road, as I read this, she was highly upset. She believed that there were these violations, and if there's that level of
Because she was angry that he was eating in uniform. Even.
Well, she was angry because he was eating in uniform. But if there's something that's that egregious, I believe that a citizen would want to hold their department responsible and would cooperate in the process and come to our office, give us a statement so that we could commence the investigation and move forward.
Okay, so the overarching thing that I have a problem with is somebody has, let's say for the sake of argument, gone out of her way to make this complaint with an egregious issue. I mean, sex in a car at a parking lot in the mall is a problem, and if her children did see it, it is a problem. So my question is, why are we putting double duty on her and not even once talking to him?
I don't believe it's double duty. It's
Well, she has to complain and then you have to interview her.
yes. I mean, we need to have something on the record aside from a complaint. We need to have an investigation. We need to have a statement besides simply what's in the complaint. I mean, we get 75% of the allegations that we get are unfounded allegations, and we know that.
Yeah,
And
that's
so,
true. It's hard to
it's-
swallow. Do you understand that
I
it's hard to
understand,
swallow?
right, but look at it from the other side. Are we going to put the officer's career in jeopardy?
Well,
and
lucky
not-
him if she doesn't show up. That's the other side.
Well, certainly, but we're trying to run a fair process here, and without statement from a complainant, actual evidence that we will put into a case file that will move forward, that will allow for procedural due process throughout this entire case. We don't have a starting point.
Okay, so is it, I'm trying to think of what else could be done if we thought outside the box, and I don't know that that is even legitimate to even propose. But would it be worthwhile to at least let the officer that you've identified know that you've received this complaint and that you're not going with, because right now she's not willing to talk to you past this? At least let him know so that if there's any action in the future, nothing, not even to him.
Well, if in fact this is a pattern of behavior for this officer, then
He'll get caught again.
it will come up again. And if if there's a notice that goes out, it may, he could change his behavior if in fact
That would be
is,
good.
if in fact that is the type of
If
behavior.
that is the behavior.
But it's not that we didn't do other things,
Well, you
we
did. That's
we
why
we looked at the CAD, we tried to get surveillance video, we tried to do other things to substantiate the allegations without the statement, but we've got to have that stepping up.
Otherwise, she could just be a disgruntled somebody and make it up.
Very much so.
No, that's legit. Okay,
I would feel comfortable if we just make a motion to send this back to the full
For
board.
what?
For them to vote on this?
send it to the non-consent
Yeah,
agenda.
non-consent
Okay,
agenda.
yeah, I'm
That
okay
way
with
the
that.
whole board can discuss it. So do I have a motion?
I move that we put it on the non-consent agenda.
And I second. All in favor? Aye.
I actually don't disagree with what he's saying,
Yeah, but, okay.
just so you know.
Okay, next we have case 25918. I don't see any problems with that case.
I don't see any problems with any of the cases other than that one
And then,
and this other one she has, I disagree
okay,
with her.
so I could call all these case numbers and we could vote at once, except for the exception of 0.
I just want to double check my notes because I
Is there anything?
wrote notes on all of them. Yeah. It was I think it was, she had a concern about 02519.
Yes, and I could call the numbers and we could.
Let's
make
just discuss that and then we can
Okay,
just
you wanna do it
go
that way?
from there. And then we could just accept all the others.
Okay.
No, I want to see what she says.
Okay.
So, Vandeventer says
Are you gonna read it
the
now?
following. This is case 02519. The pat-down being described in this case violates the Fourth Amendment of the United States Constitution and Article 2, Section 10 of New Mexico's Constitution. Pursuant to Terry versus Ohio, the officer may pat down a subject out of consideration for their own safety, but only when the officer has reason to believe someone is armed, and 2, has a hunch or an intuition. Believe somebody is dangerous. Reason to believe, as a standard requires specific facts. It has to be more than a hunch or an intuition. Behaving boisterously may be enough to satisfy the presently dangerous element, but there are no facts here that would give the officer cause to believe that this subject is armed. So as this event is described here, this pat-down was unconstitutional. If on the CADs, for example, someone stated the subject is usually armed or maybe the caller believed he had a weapon and reported that he called out, then this pat down would be okay, but we don't have those facts here. I would guess that the SOP on pat downs, which is not reviewed, is in line with the Constitution. That SOP should be applied to these facts, and most likely, again, assuming the SOP reflects the Constitution, there aren't additional facts not reflecting these findings, a violation should be sustained. I do not support the administrative closing of this case, and I also, without different information, would not support exoneration or not sustained type of finding as the specific item of the pat down. I could not disagree with her more. So I believe that that first of all, he did have a weapon on him. He had mace on him. And as I remember the case, he didn't object to being patted down. He objected after the fact. And so I don't agree with her, and I don't think we get to, she's a lawyer, but we're not. And I don't know that what she's saying is accurate. I assume she believes it's accurate, but I don't know that it's accurate, and I don't agree it makes any sense. The officer needs to be able to pat down people to make sure that everyone's safe. So I disagree and think it should be administratively closed, just as the staff said.
Okay, after hearing your argument on this, I have to agree. And I don't know if there's anything here that we need to send back for policy and procedure, or...
She can pull it out of the consent agenda if she wants.
Okay.
So, and make her case.
Okay, so do I have...
I don't agree. So I make a motion that we approve that case as administratively closed as written.
I second. All in favor?
Aye. And not just do a collective motion on all of
he
this.
was armed. He was armed with OC spray, and that happens at the very beginning in contact with the officer. So at that point, there's no question that the officer has reasonable suspicion to fear for his safety based upon the fact that he's already armed. And
Well, he didn't have the mace out, but that doesn't mean, that's the reason we have to check.
He didn't have it. He had it concealed.
Right.
And so anything after that, for the officer's safety, is fair game to do the pat down. And I believe you have the correct assessment.
Thank you.
Okay, I would move that we accept and in agreement and put on the consent agenda all the remaining administratively closed cases.
Okay, I'm going to call the numbers out just for the record. Okay, we have 259-18, 004-19, 024-19, 232-18, 260-18, 005-19, 237-18, 264-18, 020-19, 031-19, 239-18, 002-19, 022-19, 044-19, 257-18, 003-19, 023-19, and 053-19.
You forgot 02519.
Okay,
You didn't mention that one.
which one's
02519.
That one's already voted on.
Okay.
That was already-
Okay, all right.
Okay, and that's the motion.
And I second. All in favor?
Aye.
Okay, now we have exonerated unfound 05218.
I agreed with the findings. This is two women got in an altercation. The claims that the complainant made were disproved by the video. So I agreed with it being exonerated. Actually, it's exonerated, and unfounded. So I make a motion that we put that on the agenda.
Okay, I second the motion. All in favor?
Aye. This exonerated, not sustained. This is about the stolen bike. This is the bone of contention. Somebody tried to steal a guy's bike. He chased the guy. The police came out and took a report. He got the bike back. the police took a report and the complainant wanted the officer to put that it was the fault of the management of the place where he lived, that they removed a fence, and that's the reason his bike got stolen. Of course, the police report shouldn't and doesn't assign blame. It's not the officer's position to do that. He did say that he could put it in his in the CAD notes, which they did. Later, in a week or so, the bike was actually stolen, and again, he wanted the officer, the PSA, to say that it's the management's fault, and assigning blame is a court issue, not a cop issue, and so I agree with the findings of the staff were exonerated and not sustained.
Okay, so you have your motion on the table?
Yes.
And I second it. All in favor?
Aye.
A review of appeals, we don't have any. And the next case is 053-18. I'm the one that put this on the agenda because I wanted to discuss if there's something we could have done or something we missed or concerning this case, and I will read this to you. So anyway, this is an appeal case, and a letter was sent. And what disturbs me is a letter that we received back from the chief of police. And I'll read you this paragraph. And this is what he says. The POB recommends sustaining a violation of SOP 2-19-5 and SOP 19-7 by Officer V. Each of these sections of the SOP has multiple subparts. However, the POB did not indicate which subparts or requirements within the SOP 219-5 and the 219-7. It believes that Officer V violated, nor did the POB provide an explanation of reasoning. By this comparison, the CPOA determinations generally provide a detailed application of the policy of the facts and the analysis. Without similar analysis from the POB, I cannot assure I am addressing the grounds upon which the POB actually recommends a finding sustained by policy. Thus, in reviewing the recommendations here, I have used my judgment to determine which subparts SOP 2-19-5 and 219-7 the POB may have found it to be violated. And I find this quite disturbing because it's rather apparent that there's information lacking, and I don't know if it came from the board. I don't know if Director Harnesses should have given us direction and asked exactly what we need. And then also, as far as I understand, the only thing the chief received was this letter that was sent to the person with the complaint. And the letter he sent says, on December 13, 2018, the Police Oversight Board held an appeal hearing. The board hearing your presentation, the presentation, the Civilian Police Oversight Agency. It is then went into the closed session and deliberated, reached it continuous. The board recommended the findings of CPO are updated. Officer V should have sustained for violation of APD policy 219-5 and 219-7, as which the recommendations from the POB, this final decision to sustain findings and the decision of the chief of police. So this is what I'm understanding all the chief of police received. And like I said, I find it quite disturbing that he comes back and asks, what is the rest of the information?
Let's talk about the importance of this communication on case findings. I think this is really important, and we've fought long and hard to get a chief of police that will respond to us and will answer questions and give his opinion. So if our letter is not complete enough, we lose the opportunity to communicate to them specifically what our objection is to the behavior of the officer. We are asking the chief to, in the same vein, be clear in his explanation to us. What we have here is a misstep, and one that shouldn't happen again. It is a very big case, certainly lots of paper involved, and opinions and hurt feelings all the way around as far as the complainant is concerned. But the opportunity to learn from each other, the chief, that being the chief of APD and the CPOA POB, is really important. because we don't learn enough if we don't have specific enough letters back and forth. So I appreciate the chief telling us that, because it's important that he points that out. And I think there was so much communication on this that I can understand why it would be exhausting, but it's necessary that the records show what is specifically we're complaining about, why specifically we think the officers should be held to account, and that allows the chief to learn from us. So that is my opinion on this whole mess. A letter like this can't be it.
And I totally agree. So what I need from you, Director Honor, is, because this is the first appeal case, of course, most of us have ever done. And I want to know, did you know that this is the formality which we needed to get back? How we needed to explain ourselves?
He always has. We've always done it with much more detail than this.
And then I don't know why it wasn't done, or if you needed more information from us, come to us and have us explain the subpar information and what he was addressing. Like I said, I find this embarrassing to get a letter from the chief of police like this.
Do you have anything to add to
Member
this?
St. John, I was not a part of the deliberation because it was done in a closed session. And the simple announcement from the board by Vice Chair Galloway was the sustained findings. And that was it. There was no explanation provided. So I cannot substitute my judgment for your judgment. That is what was presented to me, and that is what I presented to the chief.
Okay, so moving forward, could you ever come back to us and say, you need to work on this? I don't have enough information to write.
Well, that's what I would recommend.
Yeah, I mean, I'm just saying, can you?
You're right, Mr. Harness. That is correct. You didn't have the information. I forgot that. So it is important that that information go to you specifically, and that's why Chelsea said that she had to drop the ball.
Yeah, I just wanted to bring this to everybody's attention. So, if this ever happens, and if you could come back and say, I cannot write a response, because I don't have enough information from you board members.
Correct.
And this is what I need. If that ever happens again on appeal, can you explain this?
Yeah, you can't be held to
Certainly.
explain something you weren't part of. So.
Yeah.
Certainly. And I think that, I think that that's really a contemplation for the board as to how they want to announce what the findings are and the rationale for those.
You're right.
Whether you task a board member with crafting those findings and those letters, or whether you provide your detailed explanation upon announcement. I think the other aspect of this appeal is that I really think the board needs to reconsider having their deliberations in a closed session. It should have been a public airing of the discussion.
Yeah, I think because of the circumstances of this, it just felt like it would go on all night if we didn't get to closed session and actually get it done. But you're right, the takeaway from that left you hamstrung. And that's not okay on our part, so we'll fix it.
I mean, aside from that, I think that the chief did provide a very nice, detailed explanation as to the disagreement and the non-concurrence in this case. And on the bright side, it's what we fought for 3 years.
Yeah. For sure. Maybe we should take the initiative and write to the chief and apologize for our mistake. I mean us, the board.
Yeah, I think we should, and I think that
as chair of the case review committee, maybe you could do that, because we just write a note to him on behalf of the committee and the board, saying we got your letter and we agree that it's our bad, not his.
Okay. All right. And then I think when the time is right, we'll have a discussion that maybe appeals need to be not in closed session.
Well, it isn't just appeals, it's everything that we send to the chief. This is our opinion about what's going on here, and that's usually based on what the staff investigates and finds.
Okay.
And so it's always very specific, and in this case, it's,
Okay, I
reason.
just wanted to move forward this, and
Okay.
and so when the next appeal comes in, we'll know what the procedure is. Okay? Is there anything else? Let me look at your agenda.
we don't have any appeals.
No, we don't have any appeals. Discussion? Is there anything to discuss? Okay.
No, we are going to discuss, and we were supposed to discuss, it was supposed to be on this agenda, the case with Stewart. Comparing, and not the case, but so much as what the chief concurred with and what he didn't. And we don't have it on this agenda, Mr. Larson was right. So it should be on our next agenda so that we can learn.
Okay.
And for the same reason we just discussed.
Yes,
So we need to make sure that that's on, and I don't remember the case number.
Another case, I don't know the case number.
But you know which one I mean?
No.
Okay, it's the one with the girl with the bloody underwear. It's the case that Mr. Larson just
13218.
gave us
1-3, yeah.
more information on
So we'll put that on the agenda
For CRC?
for CRC.
See, okay.
Because what we want to do is compare and contrast what the staff findings were and the chief's, because we just got a list of numbers. I agree with this, I don't agree with that. It doesn't tell us anything, we have to go through it and to understand it, so.
As a discussion item
As a
for
dis-
next.
Yes, we want to understand that.
Okay. Is there any other business? Okay, our next meeting is scheduled for March the 26th, 2019 at 11:30 a.m. And do I have an motion for adjournment?
I so move.
Can I second it? Thank you.
All those in favor?
Aye.
Aye. Okey-doke, we are done.